and welcome to Legal Basics with Sarah Law Global, and my name is Sian. Today we're going to discuss a form of intellectual property that is little known and little understood, and that is geographical indications. You might have heard a few: Scotch whiskey, Kashmir apples, Darwad Pedan. What do these things have in common? The words and the symbols refer to products and their origin, where the origin influences the reputation, the quality, and the characteristics of the goods. Usually, geographical indications will be registered for tangible goods because then the processes by which they are produced or manufactured can be regulated. Now, just like traditional knowledge, geographical indications is not a form of intellectual property that can be owned by individual. It is a communal right. Because it is a communal right, it cannot be sold and it cannot be transferred. However, when there's been an established geographical indications, some certain people can get user rights, which means they can use them to market their products. Now, geographical indications, just like traditional knowledge again, is not conferred by registration, which means people or groups of people or communities can enforce their rights when the GI or the geographical indication is registered and when it's not registered. However, when the geographical indications have not been registered, then the owners or the people that claim to own it cannot go after people that infringe their geographical indications. Now, there could be certain reasons why a geographical indication is not registered. Number one, if the geographical indication is confusing, if it refers to a place that is not definite, or maybe different places have the same name, then it will not be registered. Secondly, geographical indications will not be registered when they are contrary to any moral code of a community, if they are contrary to morality. Third, geographical indications will classically not be registered if they are likely to offend the religious beliefs of any community. Now, for any kind of word or symbol to qualify as geographical indications, it must have two qualities. Number one, it must link the goods to where they come from. It must be their true origin. Now, goods that come from place A must bear the name of place A. Secondly, the origin must essentially influence aspects of characteristics of that good. It could be the environment, it could be the technique, but the fact that the goods come from that place, it must influence their quality. Now, when geographical indications have been registered, what are some of the advantages? First, when it is registered, the owners, the group of people, the community, the association of producers, they get to build their brand. So that means the goods that are associated with that region are going to be able to build their brand in the market, and this leads to economic prosperity. Now, geographical indications are not trademarks. Although they are used to distinguish goods, they are not trademarks and they are not protected under the law of trademarks. However, unlike traditional knowledge, registered geographical indications are not indefinite in terms of term. Geographical indications will last specific periods depending with the law of the specific countries. In most Commonwealth countries and the countries that are members of the WTO, geographical indications will be protected for a term of 10 years that is renewable. Now, I hope armed with this information, you can look around your area and see what you can do for your community. What is special about things that are produced in your locality that we cannot find anywhere else in the world, such that if you were to protect that name and link it to your origin, it would be able to make your goods stand out in the market. I hope that this broadcast has been useful to you. Please write to us with your queries at cyrologlobal@gmail.com and we will be sure to answer your questions.